I will call our first case, Encompass Health versus Citizens Insurance Company. Good morning.
Donald Brownell on behalf of Citizens Insurance Company. And I'd like to reserve 2 minutes for rebuttal.
Thank you.
This matter is before the court as it relates to a provider suit under the No-Fault Act. As this panel is certainly aware, the No-Fault Act was amended in June of 2019, which has led to various analyses having to be done of the amendments to the No-Fault Act. This particular case rises out of a motor vehicle accident that occurred on December 27, 2017. In this case, Encompass Healthcare, provider of service, provided services from June 26, 2018 to October 18, 2018, all of them before the No-Fault Act was reformed. Those services were billed to Citizens Insurance Company, and Citizens Insurance Company reviewed those services and paid under the Act at the time what they believed was owed as reasonable under the Act. In this case, a lawsuit was subsequently filed. That lawsuit was filed by Encompass Healthcare on November 4th, 2019. Under the operation of MCL 531.45.2, the claims that would be available to Encompass are only those that occurred within 1 year of filing of their lawsuit. Any claims that were incurred, any services rendered more than 1 year prior to filing that lawsuit are barred under 3145. A motion was filed in the trial court indicating that the services before November of 2018 were barred, which are the services that were incurred by Encompass. The trial court, upon obtaining that motion, got responses. The plaintiff raised the issue of tolling that was part of the No-Fault Reform Act. The No-Fault Reform Act in June 2019 added equitable tolling to the reforms. That was added after these services had already been incurred, adjudicated, and paid by citizens. The trial court, upon obtaining that motion, granted citizens' motion indicating that the services at issue were barred under the 1 year back rule, and the services were barred even if one were to consider the tolling argument because EOBs were issued. So hundreds of EOBs were issued indicating that of the bill, a certain amount was deemed to be reasonable and was paid. Those were communicated to Encompass, and the trial court said that those claims were barred as a matter of law under 3145. Now, the issue of tolling was raised by the provider, by Encompass, arguing that the new statute, which codified tolling, was somehow applicable to services rendered before the statute existed. So before the legislature passed the reforms, 3145 did not contain equitable tolling. It did not contain statutory tolling. It simply did not exist. The Supreme Court of Michigan had interpreted that statute indicating there was no tolling, and that had been the law for over a decade. When citizens received this billing and reviewed the billing, tolling did not exist. It was this court, the Supreme Court of Michigan, who said it did not exist. So in 2018, unless an insurance adjuster had some amount of clairvoyance to know that a year later, in 2019, the legislature was going to change the law, they could not have known that this new provision would be put forth by the legislature. The argument that has been made by Encompass, although they admit all the bills were incurred before reform, all the bills were adjudicated before reform, they now want to argue that the obligation of citizens was to communicate under subsection 3 a specific and formal denial. The fact of the matter is the bills had already been adjudicated a year earlier, and those bills had been received, reviewed, and EOBs sent. So to suggest that a statute that didn't exist at the time somehow revives a claim would go against the application of that to the law at the time.
But didn't Citizens argue in its motion for summary disposition under the statute? The tolling provision in the statute. It was Citizens who said right, and cited the amended statute and said that it was satisfied under tolling. It was Citizens who brought that. Why did Citizens not waive the argument you're making now?
Well, Citizens did not waive the argument, Justice, because at the time, the argument was that under subsection 2, meaning the straight one-year back rule, the bills were barred as a matter of law. It was Encompass who said, no, we are entitled to use this new statute and apply it to bills that were incurred before the law was passed. That was not our argument. It was not Citizens' argument. What we did was we quoted in our motion the entirety of the statute as it existed at the time, because to do otherwise in 2020 would have been misleading to the court.
But you didn't make this argument that you're making here, and that spine specialists actually held that the new provision doesn't actually relate back or doesn't apply retroactively. You said that you met the question of formally denied the claim.
We indicated that if the court was going to consider, we argued in the alternative, that number one, we never got there because the bills were barred 1 year back, not 1 year back. There was no formal analysis to be done about denials or non-denials. 1 year back meant 1 year back. However, we argued in the alternative that if the trial court judge was going to consider subsection 3, that the EOBs themselves formed the basis of a denial, which the trial court agreed with. And so we argued in the alternative, which certainly we're entitled to do. But as this court is well aware, the issue of retroactivity had not yet been opined on by anyone. And so the issue was, were these bills barred by 3145? And they were, subsection 2. Encompass argued, no, we'd like you to revive our claim under subsection 3. And we said, well, number one, that's an alternative argument. Number two, even if you did that, if you made that argument, they were denied because the EOBs were issued. If it was a $1,000 bill, we sent a detailed EOB and we submitted them all that says we're paying as reasonable $700 and we're not paying the rest. And so the argument is that certainly the new statute could not have applied to these bills, but even if you do, we still win.
Okay.
So in this case, the issue of the application of the new statute was raised not only in the trial court, and in the trial court there were various orders entered to clarify what the court meant, and then it went to the Court of Appeals. And the Court of Appeals, for the first time, indicated that the legislature, when they passed no-fault reform, was somehow doing so as a curative instruction about DeVillers. There is nothing in no-fault reform that says that. No-fault reform was not curative of a case that was decided by the Michigan Supreme Court over a decade earlier. The fact of the matter is the law in place at the time that these bills were adjudicated was 3145, and equitable tolling or statutory tolling did not exist. So in this case, the Court of Appeals decided to argue that no, the real focus here is the application of a curative legislation to revive what 3145 had been interpreted by courts before DeVillers. And the fact of the matter is the Court of Appeals was mistaken in that viewpoint. There's nothing in the legislative history, there's nothing in the reform statute to indicate that this was a curative instruction. The legislature didn't say after DeVillers a decade ago, we need to solve that. That's not what curative legislation is. So in this case, the Court of Appeals focused only on the portion of 3145.
So are you arguing that there's a temporal restriction on when legislation can be curative? I mean, what about the argument that it took 12 years to get a legislature that might have been receptive to not only this provision but other provisions, thinking of covenant giving providers an ability to sue themselves. I mean, there are a number of changes, right,
Yes.
in this legislation that was all-encompassing, that included a number of things. Why, I get that it took 12 years to do that, but why don't we look at what the legislation says and what was the law previous and look at whether or not that was curative?
For many reasons. One, if the legislature had decided to overrule DeVillers, they could have said so. They could have indicated in legislative history that's what they were doing. They also could have opined on whether 3145 would apply prospectively only or whether it would apply retroactively. They did not. And so if this exact situation, this is a date of loss before reform. And what's different is there have been discussions about services rendered after reform and how those are to be adjudicated. That's not this case. This case involves services rendered to an insured before reform was even passed. The law didn't exist at the time. And so in this situation, the attempt here by the Court of Appeals is to apply a new law to services that had already been rendered and had already been adjudicated before the law was passed. If the legislature intended that under 3145, if they intended to revive claims that had already been determined, they could have said so.
Well,
but they didn't.
But here, I mean, and I get your point of saying that you didn't waive the argument, but from the Court of Appeals perspective, they decided this case saying, assuming, as it had been argued below and in front of their court, that this tolling provision is the relevant provision to be looking at. They didn't engage in any of this discussion, right? Because they just went to whether or not actually that statutory provision was satisfied as far as formally deny.
Right.
So the Court of Appeals really wasn't asked to engage in this, so I don't know that we can necessarily fault them for not or engaging in it incorrectly, as you're arguing now.
The Court of Appeals was asked to indicate that the bills were barred under subsection 2 and that no equitable tolling or statutory tolling even applied. That's what they were asked to do. What they did was determine that no, we believe that subsection 3 of the new statute applies to these bills incurred a year earlier and before the law was even passed. And then they went further, as you know, and said in order to formally deny under this new statute, you have to use a very specific denial word and indicate to a provider of service that those services are denied. And without that, then tolling exists essentially forever. And to do so would revive numerous claims that have already been billed and paid under the analysis done by the Court of Appeals.
Is there a difference between, if we were to look at this, between claims where the 1 year back and 1 year statute of limitations would have accrued and expired before the legislation and sort of a straddle claim, like say, you know, claim or expenses incurred in April or May of 19, but their 1 year hadn't expired? Is there a distinction to be made between those two types of?
There's not, because the law is very clear. The date that we look at is not the date of filing of the complaint. We look at the date that the service is incurred. And then, once it's incurred, we look, did they file suit within 1 year? That's the analysis that has to be done.
Well, that's the 1 year statute of limitations.
Yes, well, statute, yes, if you want to call it
And then there's
limitation.
the 1 year back.
Well, the 1 year back is, we look back 1 year. And that's
From
when
the
bills-
filing.
From the date of filing to the date they incurred the bill. So they can continue to, it's not a statute of limitations though, they can continue to file suit, and anything within 1 year, they can try to recover. So I think
Counsel, yeah, I just wanted to ask a little, I just wanted to skip forward to the formal denial
Sure.
section, understanding there's a threshold to get to that, but I just want to ask a little bit more about it. You've argued that the No Fault Act requires flexibility and that the definition embraced by the Court of Appeals is inaccurate. I'm sort of struggling to understand how the definition is wrong, that it has to be explicit, that you actually have to say denied. It just doesn't feel that hard to me. So could you
Here's
help
why
me
it's
out?
difficult, because every bill is different, and every bill is adjudicated under the law, and depending on the law. At that time, the law was those bills had to be adjudicated as what is reasonable. Customary charge, reasonable payment. That's what was done. To suggest that, and by the way, the rest of it is denied, requires them in every single bill to look at the rest of it. What their job is, and what they've been instructed to do under the No Fault Act since its beginning, is prompt payment of a reasonable amount for the service. And that's what they've done, and they communicated that. And they do so every day, as does every other carrier. And that's what they do. So I see my time. I'd like to reserve some time for rebuttal. Thank you.
Thank you.
Good morning. May it please the court. Don Fulkerson, and I represent the plaintiff appellee, Encompass Healthcare. I'd like to introduce Harold Parakis, co-counsel, and he represented the plaintiff in the trial court and the Court of Appeals. This is just the Court of Appeals. Oh, okay, I'm sorry. I am 10 days out from COVID. I'm being abundantly careful. I don't want anybody to possibly get COVID. It was awful when I had it 10 days ago. And I still have some symptoms. Now that I'm in my harbor here, let me make my 3 points that I want to make before we move on. My first point is the citizens clearly waived this argument. They waived any argument that the 2019 amendment to creating 3145.3 doesn't apply because it came after the accrual of the plaintiff's, the benefits incurred by the plaintiff. They waived it in their, on the record at the motion for summary disposition hearing expressly. They agreed with the trial court that the statute, that the tolling provision applied and governed in the case. They agreed with this position in their response to the plaintiff's motion for clarification. They agreed with it in the Court of Appeals. If you look at page 9 of their brief in the Court of Appeals, they say their issue is not that it should not have applied because it predated the accrual or it postdated the accrual of the claim. Their argument was just that the trial court correctly held there was a formal denial and that therefore the claim was barred because it was more than 1 year after the last incurred claim was formally denied. And Health Partners and Giramonti look at this issue and say that issue was never disputed in the trial court or Court of Appeals in this case. So we have a waiver here. My second point relates to the third issue in our MOA order, which is the proper standard for defining a formal denial. The Court of Appeals clearly applied the law stretching back from the Bork case all the way through Jimenez and Smitham, and they adopted the proper standard. Citizens does not address any of those decisions, and Citizens doesn't offer their own proposed definition of what constitutes a formal denial, just as Justice Welch pointed out, well, it has to be flexible, whatever that means. The standard was properly adopted by the Court of Appeals and applied in this case. And my third point regarding application of the 2019 amendment is it does apply in this case for the simple reason that under the Buell factors, we don't have a vested right, we don't have a contractual obligation that's being retroactively imposed on citizens, and we don't have a tort duty being retroactively imposed on tort duty, but on citizens.
Help me understand though, I mean, when the charge was incurred, say April of 19, before the statute is enacted, at that time it's incurred, it is subject to a 1-year statute of limitations, right? And at that time, that if a suit is filed more than a year after that, you know, it is imbued with this 1-year limitation at the time it's incurred. And at the time it's incurred, there is no tolling. Why is that not the relevant time to look at it as when the expense is incurred as opposed to when suit happens to be filed?
Because it's not, if you apply the Buell test and LaFontaine before that and In re certified question before that, it meets the standard for retroactive application of an amendment. It just does. We don't have an abolition of a cause of action, or we don't have the abolition or the imposition of any contractual obligation, and we don't have any effect on a tort duty. And we have a remedial statute that was passed unquestionably. Even the amicus brief in the spine specialist case, which is next up on the docket, they concede that the amendment was remedial. Now, we argue that it was both curative and remedial, and it clearly was. It was passed by the legislature to reinstate Lewis and overrule DeVillers.
Do you think there's a difference, like I asked your brother counsel, between a claim for expense that had accrued and expired prior to the legislation, or one that sort of straddles it, like here, like incurred in April or May of 19, but that 1 year hadn't run when, for the first couple of months, there was no tolling, but arguably that sort of straddle thing. And I'm thinking in terms of, I'm sure you're familiar with our decision from McLean last year, of saying that when a cause of action has accrued and expired prior to a statutory enactment that might otherwise have revived it, that's not sufficient to
Right.
send
This
it back.
this case is not the same as McLean, Your Honor, because as this court has repeatedly held, and the Court of Appeals has held, tolling relates to a reduction in damages. It is not the same as a statute of limitation. And what the court took up in McLean was the reviving of a discovery rule for statute of limitations involving, child assault issues. And that involved a retroactive imposition of new tort liability or new liability. That we don't have that here. We don't have an issue here involving retroactive application of a statute of limitations. All we have is an application of a damage reduction provision. And it's distinct. Go ahead.
I understand the difference between a statute of limitation and the argument between that the 1 year back is not technically a statute of limitations. I think that's pretty clear. But what I'm struggling with is that subsection 3 says that a period of limitations applicable under 2, which is both the 1 year statute of limitations and the 1 year back, to the commencement of an action and the recovery of benefits is told. So sub 3, to go back, I understand here we're just looking at the 1 year back rule, but that
Right.
sub 3 actually does affect a tolling of the statute of limitations as well.
If there's an argument about the statute of limitations, that may run into an analytical issue with McLean. I agree with that. But it doesn't here.
It doesn't here because you're arguing the 1 year back.
Correct, and
is
that's the only
different
issue
than-
before the court.
Okay.
And I would point out that I believe that in-res certified questions is controlling. In-res certified questions dealt with the issue of the passage of a comparative negligence statute in product liability cases, a statute that was passed after accrual of the plaintiff's cause of action. And this court held that it did not impair vested rights because it didn't deprive the plaintiff of the remedy of the tort claim. It merely potentially affected the amount of damages recoverable. And that did not run afoul of the subsequent Buell test or LaFontaine or the elements, the 4 elements of determining application of a statute. And here we have, again, we don't have any change to the 1 year back rule. We had a remedial and a curative legislation to reinstate or establish the tolling rule it did not abolish the defense of 1 year back. It merely affected the amount of damages potentially recoverable. And I don't see how in-res certified question is not controlling and does not resolve this issue. So
from your perspective, is DeVillers still good law?
I'm sorry, Judge, go ahead.
From
Justice,
your perspective, is DeVillers still good law?
is DeVillers good law now?
Yeah.
No.
Okay.
No, I believe that in passing the statute, the legislature overruled DeVillers. And I think that it's pretty clear they did because what was enacted in 3145.3 was the identical rule in Lewis, both involving the tolling for 1 year after the formal denial and the standard that the claimant must exercise reasonable diligence. And that point is very important because a lot of policy arguments have been made either in this case or in the spine specialist case that this is going to encourage stale claims or gamesmanship. The claimants still must exercise due diligence. I don't think we're looking at a situation where we're going to have a resurrection of 10-year-old bills. I mean, that would not be due diligence here.
Counsel, I know, and you addressed this somewhat, and we asked about it, but how do we square Andery? We know in Andery that plaintiffs got the benefit of sort of the statute locking in via sort of a contractual statutory obligation. Why isn't it the same here? I mean, why doesn't the defendant or citizens get the same benefit?
For 2 reasons, Your Honor. First of all, the court was very clear in Andery that you were only evaluating the fee schedules in 3157, and paragraph 7 and some paragraph 10. None of the other portions of the 2019 amendments were at issue in Andery. That's the first response. The second response is, Andary dealt with a vested right. It dealt with the right that the plaintiff had contracted for unlimited no-fault benefits. That was then abolished, or at least significantly altered by the 2019 legislation. Here we don't deal with a vested right. And I have to
But
emphasize.
didn't the insurance company have an agreement that incorporated the law that existed at the time, which of course didn't have equitable tolling? So what, I mean, isn't it kind of the same thing?
I don't believe it is. I mean, it only potentially, the real crux of the issue of retroactivity deals with, is there or is there not a vested right, or the imposition of a contractual obligation or tort duty. We don't have any of the three here, so it doesn't run afoul of element 3 in Buell. It did run afoul in Andary, and it's a clear and crucial distinction. I point out that in our brief, we cite cases stretching back decades that reaffirm that a statutory defense is not a vested right. Rookledge and several other cases, Seaton, and none of those cases are addressed. The only case that gets addressed by any of the parties, any of the interested parties, is in IAM's amicus brief. They cite the case of the Johnson case. And Johnson dealt with the amendment to the Wrongful Death Act regarding non-viable fetuses. But obviously there you had the creation of a new tort, which could not be applied retroactively, barring, again, you didn't have an overcoming of the presumption of prospectivity, which is when the legislature doesn't specifically designate the statute as being retroactive, which we have here. So
just so I understand, you would tell me I'm over-reading Andary if I said to you that I read Andary to hold that the revisions to the No Fault Act were intended to apply prospectively.
yes, I believe. I mean, again, I think Andary is much more of a specific holding, and again, it relates to the nature of the vested right that the plaintiff possessed by paying for and contracting for no-fault benefits that at the time were lifetime benefits. They paid a premium for that, and we don't have that here. So I'm not sure where my time is here, but
2 minutes.
I have a little bit more time. I want to point out that I want to reiterate on the issue of the proper standard for formal denial, that one of the arguments that Citizens has raised is, well, when they're talking about this issue of we want flexibility or we need flexibility. There's nothing that is in any way implicated by the Court of Appeals definition that would hinder insurance companies from either denying a provider's bill in its entirety or denying it in part. The test of being unequivocal and direct and impressing upon the claimant of the need to pursue a remedy in court. Or if there's a partial denial, which happened here, the denial has to say, look, we are denying any liability beyond what we've paid. There's no problem that's created by just having that requirement. It doesn't in any way hinder the flexibility of insurance companies to issue EOBs. It's a pretty clear and easily workable standard. So having said all that, I asked the court to either deny Citizens' application for leave or to affirm the Court of Appeals ruling. And unless the court has any other questions, thank you very much.
Thank you.
Okay, it's all good.
Nothing personal.
What's happening?
Just wiping down.
It's hard to cover up the microphone.
Oh.
I hope so. in response to a couple of the issues that were raised. One, counsel directed the court's attention to the rights of the claimant as set forth in Andrew, but he missed one important point of Andrew. Andrew talks about the idea that the rights and obligations, okay, it's a contract, and the obligations of citizens in this case were set at the time these bills were incurred and adjudicated. And so the obligations were also set at that time. And so citizens, in reliance to the law in place at the time, adjudicated the bills. And the other thing to address is the flexibility issue. Bills are not simply paid in part or denied. Bills are paid, there are requests for additional information. The system is intended to work for the prompt payment of bills for the benefit of injured parties.
Is there ever a point in time where there's a definitive denial? I mean, where you cannot come back and say, look at this again?
And the point there is, the reason for flexibility is, I suppose it's possible that there could be an absolute denial, but in many cases, we have reasonable proof, the standard under the Act, to pay these bills, and if you want us to consider the rest, please submit additional information, which they do all the time. And in this case, there are resubmissions and resubmissions. So we can't know what we might get in the future to say, for all time, this will be denied.
So would you say that process that you have and the flexibility there is to the benefit of the insured?
Yes, because if we were to communicate this is an absolute denial, they're not going to submit any additional information because they think this will never be paid. So the idea is to avoid the litigation that might ensue. They submit additional records, additional medical bills. We might look at those and say, okay, this is related to the motor vehicle accident, and we should pay the remainder of that. Thank you.
Thank you. Thank you both. The case will be submitted.